Welcome to this custom-tailored deep dive. We're really thrilled to have you joining us today.
Yeah, glad to be here and to get into this one with you.
So let's just unpack a fascinating legal puzzle. It's one that gets right to the heart of how business is actually conducted in the real world. I want you to imagine this scenario.
Okay.
What happens when two people make a contract specifically for your benefit, but one of them completely flakes on their end of the bargain?
Right, they just walk away.
Exactly. Do you still get to enforce your payout? Because you are sitting there expecting a check, right?
Yep.
Your name is explicitly written into the contract.
And you've already factored that money into your life.
Yeah. But behind the scenes, unbeknownst to you, the whole deal is just fallen apart. The person who was supposed to do the work to trigger your payment just walked away.
It's a rough spot to be in.
It really is.
Yeah.
So where does that leave you? Do you have an absolute right to that money, or does the underlying failure destroy your claim?
Well, that is exactly the friction point we're going to figure out for you today. In this deep dive, we're going to rigorously examine the rights of what the law calls third-party beneficiaries. It's a concept that, it sounds straightforward but gets incredibly thorny in practice.
Oh, definitely.
More specifically, we're going to explore how those third-party rights are impacted by the defenses, or what the courts traditionally call the equities between the original two parties to a contract.
Right.
By the end of this discussion, we are going to build a comprehensive analytical path for you. We'll give you the exact framework so you can see exactly how courts untangle these complex three-way legal relationships.
And ultimately decide who gets paid and who gets left empty-handed.
Exactly.
That's a critical distinction to make, especially since so much of modern commerce relies on these three-way payment structures. Let's start by laying the groundwork just so we have a solid foundation before we look at the case law. Could you define the core legal concept we are dealing with here?
Sure. So the foundational concept we are exploring today is the general rule regarding third-party beneficiaries, which we derive directly from our source text. It's a principle designed to prevent unjust enrichment. The general rule states that where a contract is entered into by two parties for the benefit of a third, the third party's rights are subject to the equities between the original parties.
So, subject to the equities.
Yes.
In plain English, does that essentially mean the third party steps into the shoes of the original promisee, like inheriting all the baggage and flaws of the original deal?
Precisely. It means the third party doesn't just get a magic, untouchable right to be paid just because their name is on a piece of paper.
Right, it's not a blank check.
No, their rights are tethered to the harsh reality of the contract between the original two people. If the deal is broken, the third party's rights are broken too.
Got it.
And analytically, this rule hinges on three distinct conceptual elements.
Okay, let's hear them.
First, there must be a contract intended to benefit a third party. Second, there must be a condition or equity tied to the promisor's obligation to pay. And third, we have to look at the promisee's fulfillment or their total failure to fulfill that specific condition.
That makes a lot of intuitive sense. It protects the person writing the check from paying for a job that was never completed. Let's analyze Alexander H. Revell & Co. VCH Morgan Grocery Co. First, what are the legally dispositive facts?
The facts here stem from a classic business dispute that just spiraled out of control. We have a man named William Lidd, who was hired as a contractor to install fixtures for the C.H. Morgan Grocery Company.
Fixtures like commercial shelving and lighting.
Exactly. Displays, that sort of thing. To actually do this job, Lidd had to buy those fixtures from a supplier, which in this case was our third party, Alexander H. Revell & Company.
Okay, so Revell is the supplier.
Right. So Lidd gets the materials and installs them in the grocery store, but the installation was entirely unsatisfactory to Morgan Grocery. It was a botched job.
Yikes.
Yeah. And a bitter dispute broke out over the quality of the work.
Which is a nightmare for any retail business trying to open its doors.
Oh, absolutely. So to settle this controversy and avoid litigation, Morgan Grocery and Lidd met and signed a written settlement agreement on May 22.
Okay, the May 22 agreement.
In this agreement, Lidd promised to go back in, finish the work properly, and waive any payment for the extra labor or materials required to fix his mistakes.
Fair enough.
In return, Morgan Grocery promised to pay the $1,100 balance it owed Lidd, but they agreed to do it by paying $671.80 directly to the supplier, Revell & Company.
It sounds like a very practical way to settle a debt. Morgan gets their shelves fixed, Litt clears his debt with his supplier, and Revell gets the money they are owed for the materials.
It was a great plan on paper, But here is where it all falls apart in reality.
Oh, boy.
After signing that May 22 settlement agreement, Lid ultimately did zero work. He completely failed to perform his end of the bargain. He didn't fix the shells, he just vanished from the job site.
Wow. Just walked away.
Exactly. And despite Lid's total failure to fix the installation, Revell and Company, the third-party supplier, sued Morgan Grocery, demanding that Morgan hand over that $671.80.
So Revell is saying, hey, we are named in the May 22 contract. You owe us.
Yep.
And what was the core legal issue?
The precise legal question the court had to answer was this. Can a third-party beneficiary Revell recover a specified sum from a promisor Morgan when the promisee Lig totally fails to perform the work that served as the condition for that payment?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied this black-letter rule. The third party's rights are subject to the equities between the original parties. We can break this down into three testable elements. First, third-party beneficiary status. Second, the conditional nature of the promise. Third, fulfillment of the condition by the promisee.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, third-party beneficiary status?
So the fundamental sub-issue the court had to resolve first was whether Revell was actually intended to benefit from this May 22 settlement. The governing sub-rule is that a contract must explicitly direct a payment or a benefit to the third party to establish this legal status. You can't just be an incidental bystander. You have to be the target of the benefit.
So they look at the contract itself.
Yes. Applying the facts, the court went straight to the text of the May 22 written agreement. That document explicitly stated that Morgan Grocery would pay Alexander H. Revell and Company the sum of $671.80.
Very clear.
Extremely clear. So the court's conclusion on this element was that because Revell was explicitly named in the text to receive the funds, the first element is met. Revell undeniably held third-party beneficiary status.
Understood. Now, what about the second element, the conditional nature of the promise?
Here, the sub-issue was whether Morgan Grocery wrote a blank check, or if their promise to pay was tied to a specific condition or equity. The sub-rule dictates that courts look to the plain language of the agreement to see if payment is dependent on a specific performance.
So back to the text again.
Always back to the text. Applying the facts, the court zeroed in on the exact phrasing of the May 22 contract. The document read, "As per our recent agreement regarding the completion of all work as per contract with you, I will do as follows. In return, you are to pay the balance to Alexander H. Revell & Co."
Ah, in return.
Yes. The phrase "in return" is absolutely critical here. The court concluded that this language made the obligation strictly conditional. Morgan's promise to pay the third party was entirely dependent on Libp going back into the store and completing the specified work.
Understood. Now, what about the third element, fulfillment of the condition by the promisee?
Finally, the court had to ask the sub-issue. Did Liddy actually do what he promised to do? The sub-rule here is straightforward. The promisee must actually carry out the condition in order for the promisor to become liable to pay the third party.
Makes sense.
When applying the facts, the court noted a glaring, undeniable admission. The plaintiff in the case, Revell, openly admitted in court that Lig did not do any part of the work he had agreed to do in the May 22 settlement.
They just admitted it.
They had to. He vanished. So the court's conclusion on this element was that the condition was completely unfulfilled. Lidgate's total failure to do the work created a valid defense and equity for Morgan Grocery.
And after analyzing all the elements, what was the court's final conclusion?
Justice O'Connor delivered the ultimate holding. Judgment affirmed for the defendant, Morgan Grocery.
Wow.
Synthesizing the elemental analysis, the court reasoned that because Lidgate failed to perform his side of the deal, which is element 3, Morgan's conditional obligation to pay element 2 was never actually triggered.
Got it.
This means that Revell's rights as a third-party element 1 are entirely blocked by the equities between Morgan and Lig. Justice O'Connor stated that allowing Revell to recover the money when no work was done would be against all sense of justice and fair dealing.
It is incredibly satisfying to see the court break it down so logically. It aligns perfectly with how most people view fairness in business.
Right.
Why should Morgan pay for a fixed store when the store is still broken? But, as we know, the law is rarely unanimous. Brilliant legal minds can look at the exact same facts and see a completely different reality.
Very true.
To ensure you get a well-rounded view of this concept, let's look at the other side of the bench. What was Justice Taylor's dissenting opinion all about?
What's fascinating about Justice Taylor's dissent is that he isn't ignoring the facts. He is looking at the fundamental architecture of the contract differently, using a bilateral contract analysis.
Okay, how so?
Justice Taylor argued that we need to look closely at what the actual consideration was in the May 22 agreement. In contract law, consideration is the value exchange between parties.
Right, the give and take.
In Taylor's view, the consideration wasn't Lit actually doing the work.
Oh,
No, the consideration was Lit's promise to do the work, alongside his promise to waive extra fees.
so because they exchanged promises on paper, Justice Taylor believed the deal was locked the second they signed, regardless of what happened on the job site afterward.
Precisely. It was a mutual exchange of promises. Because of that, Justice Taylor viewed Morgan's obligation to pay Revell as fixed, binding, and unconditional the very moment the ink dried on the contract.
That's a huge shift in perspective.
It is. Taylor pointed out a crucial detail about the text. The written contract didn't explicitly say, "We will pay Revell when the work is done," or "after Lick finishes,"
I see.
because there was no specific temporal condition, no timeline written into the text regarding the payment to Revell. Taylor concluded that Morgan became bound unconditionally at the time of execution.
Wow.
Therefore, even though Lipke breached his promise later by not doing the work, the third party, Revell, had a fully vested right to sue and collect immediately.
That is a staggering difference in interpretation. It really highlights the philosophical split in contract law. Does contract describe a sequence of future events that must happen in order, or does it represent an immediate snapshot of binding obligations?
Exactly.
It shows how dangerous a vaguely worded settlement can be. But for our purposes today, the majority rule is what governs. Let's pivot to testing this difficult rule.
Okay.
We need a way to make sure this sticks. Give us an unforgettable, visceral hypothetical to help lock this concept into memory.
Okay, let's call this the gross sewage hypothetical.
Oh, this sounds fun.
Imagine a homeowner who will serve as our promisor and a local plumber who is our promisee.
Yeah.
They sign a contract to clean out a grotesquely overflowing biohazard-level sewage-filled basement.
Disgusting.
It is an absolute unimaginable nightmare down there. The homeowner promises to pay the plumber's outstanding past-due credit card bill.
Okay.
The credit card company, in this scenario, is our third-party beneficiary. But this promise to pay the credit card company is explicitly made if the plumber clears the foul mess.
A very strong financial incentive for the plumber to deal with a horrific job.
You would certainly think so. But the plumber shows up to the house, takes one look at the waist-deep sludge, smells the unimaginable stench, drops his tools, and completely runs away.
Just bails.
Cowardly flees the scene and does absolutely zero work. Later, the credit card company, having heard about this contract, tries to sue the homeowner for the money.
Right.
If we apply the rule from Revell v. Morgan, what happens? Just like in the case, the third party gets nothing.
Makes sense.
The credit card company's rights are entirely subject to the equities between the original parties. And the defining equity here is the glaring fact that the plumber fled the sewage instead of fulfilling the condition of the contract.
So the homeowner owes nothing to the credit card company.
Exactly. The homeowner's obligation to pay the third party was never triggered because the basement is still full of sewage.
Right, so the credit card company is sitting miles away in some corporate office expecting a check, but they have no idea the plumber just ran away from a biohazard. They inherit the plumber's total failure.
That's the perfect way to phrase it.
You cannot claim the benefit of a contract if the foundation of that contract, the actual performance, has completely crumbled into waist-deep sludge.
Well said.
That is a deeply unpleasant image, but it perfectly illustrates the concept. Let's bring this all together for you into a practical, actionable tool. Could you synthesize the rules we've discussed into a strict exam framework?
Gladly. If you want to master this doctrine for issue spotting and structured analysis, you need to use this strict four-step diagnostic checklist. Don't just rely on intuition. Apply these steps sequentially.
Let's get into it. Step 1.
Step 1. Identify the trio. You must clearly map out who is the promisor, who is the promisee, and who is the third-party beneficiary. Get those roles defined immediately so you know whose rights are at stake.
Essential first step. Step 2.
Step 2. Classify the promisor's duty. Look strictly at the text of the agreement. Is the promise to the third party absolute and unqualified, or is it a conditional exchange based on the promisee doing something? You need to hunt for restrictive phrases like "in return" or "upon completion."
Got it. And step 3?
Step 3. Evaluate the promisee's performance. Step out of the contract text and look at the facts on the ground. Did the promisee actually do the work they promised to do, or did they totally breach the contract and walk away?
The reality check. And finally, step 4.
Step 4. Apply the equities block. If you find that the promisee failed to perform in Step 3, assert that failure as a shield. That failure is the equity that blocks the third-party beneficiary from collecting anything from the promiser.
That checklist is incredibly helpful. It takes a complex, messy web of human relationships and turns it into a rigorous, straightforward
It
sequence.
really does. It gives you a roadmap to find exactly where the liability breaks down.
Definitely.
If we connect this back to the broader implications of what we've learned today, I want to leave you with a final thought to mull over.
Okay.
Think back to Justice Taylor's dissenting opinion. If Justice Taylor's view of bilateral contracts had become the law of the land, imagine the real-world consequences for everyday commerce.
Oh, wow.
Any business owner settling a dispute could be forced to pay thousands of dollars to total strangers, even if the contractor they hired completely abandons the job the very next day. Think about how radically that would change the way every single settlement agreement in the business world is drafted today.
They'd have to be bulletproof.
Exactly. Lawyers would have to invent entirely new, massive layers of protective clauses just to avoid paying out on broken promises.
It really puts into perspective how a single interpretation of a few simple words like in return can shape the entire landscape of business negotiations and protect companies from financial ruin.
Well, thank you for joining us on this deep dive. We hope this analytical journey has given you a powerful new lens for looking at contracts and the hidden risks within them. Until next time, keep analyzing, keep questioning, and keep diving deep.